so far as role of councils are concerned, not just pertaining to construction arbitration, but in fact, for that matter, for any matter as such, the primary duty and
How are you all? Hopefully, all of you guys will be healthy at your home. Today's your host, Shubham Kumar, and welcome back to Legal Talk series once again. Today, I am going to introduce you to all the people. His name is respected advocate Mr. Dharmender Verma, sir. And Mr. Dharmender Verma, sir, is present among us today, and he has 8-year experience in the field of litigation. And right now, he's the partner of Maheshwari and Co. I am warm welcoming you, sir, that you took out your precious time for us. Thank you, sir, for joining us today. And thank you, sir, that you came on Legal Talk with Shubham.
Thank you, Shubham. Thank you for having me here on your channel.
Thank you, sir. And my first question is for you. I would like to know about your background first. Where are you came from and where did you complete your education? And what was the time that you think you should go ahead and become an advocate?
So, Shubham, my background is my father was in a government job. So I'm from Shimla, Himachal Pradesh, and my father was in a government job, which was transferable job. So my schooling, so far as schooling is concerned, it has been throughout India. I have studied, and I have had the opportunity to study 3 years out of India also. And after that, after coming back to India, my journey started, and I completed my graduation here, and then my law completed. I have completed from Delhi University in the year 2013. And thereafter, from 13-14 onwards, I had started my journey and started practice.
So my second question is for you. So what is the role of counsel in the case of construction arbitration?
So, Shubham, so far as role of counsels are concerned, not just pertaining to construction arbitration, but in fact, for that matter, for any matter as such, the primary duty and foremost for any counsel is to bring forth the true and correct facts and to represent his counsel to the best of his ability and to serve a purpose and get the relief and justice for him. So far as construction arbitration is concerned, from a point of view of a counsel, it depends the party you are representing. We can be there for the contractors in the construction arbitrations, or we can be representing a organization, some organization involved. So it totally depends on the party that we are representing and the case that we have in hand, what kind of a relief that we are seeking. But the foremost and primary duty for any counsel would be to represent the party to the best of his ability and to get the relief for his client.
So could you think that how much far is different from the court, sir?
Shubham, so far as arbitrations are concerned and litigation or courts are concerned, they go hand in hand. So for arbitrations, if the parties are ad idem and they decide that ATP constituted for the adjudication of disputes, see, the arbitration arises out of the disputes, and disputes, they come from the contracts. So for any party, when the parties are ad idem on a contract, and in that contract some dispute comes up, then obviously the matter is taken as per the arbitration clause of that agreement for the adjudication of the disputes. So if the parties are ad idem, the matter can be directly taken to the before the arbitral tribunal. The arbitral tribunal is constituted and the matter is adjudicated on. But if that does not happen, then the parties have to get the arbitrator tribunal constituted through the intervention of the court. And after the matter is adjudicated, the executions and the enforcement of the awards is done through the courts. So we can say they go hand in hand, but it is something that a journey from the constitution of the arbitral tribunal and to the execution and enforcement of an award, they go in hand in hand.
So is the arbitration is different from the mediation and conciliation?
See, arbitration is a one way of adjudication of the disputes, we can say, and it forms a part of mediation and conciliation also. So mediation and conciliation is a prerequisite. There are modes to adjudicate on the disputes.
Okay, sir. Got it, sir. And what is the pros and cons of construction arbitration?
The pros and cons of construction arbitration, see, construction arbitration itself is a field wherein some expertise on subject is required. Because construction, you need to know the technical know-how, the involvement. If I mention here, the involvement would be, the disputes, adjudication of the disputes. So some technical skills are required, some technical expertise are required to adjudicate on these disputes. So you need to have the knowledge of the, first of all, the construction, the buildings, the maps, the drawings, or particularly the area wherein you are practicing. Let's say if I give an example here, let's say a road construction project is there and the disputes arises out of that road construction project. Then to adjudicate on that dispute, you need to have the knowledge what goes in the building and built up of that road. So you need to know the laws that are involved there, the technical aspects of it. So this is something wherein the requisite technical expertise are required. So these are some cons, and the pros, obviously, pros are these are cost effective. Arbitration is cost effective method to adjudicate on the disputes, and time management is there. If you take the matters before the courts, we understand that today in India we have pending litigation and it takes years and years to resolve the disputes. So this is one mode wherein you can effectively adjudicate on the disputes and get the relief remedy quicker than the courts.
Basically, this is a quite different from the court, and this is the very effective tool when you come into the legal fraternity field.
We can say that because, see, today the courts are also inclined on the parties to get the matter resolved amicably. So we can say that even we all know that in commercial courts today, it is a prerequisite that the parties are required to take the matter to the mediation before they take it to the court. So even the courts are trying, and it is the intention of the legislature to get the matters adjudicated amicably if possible. Otherwise, obviously, as a last resort, we have to go in litigation and get the matter resolved through courts.
Third question is for you. So, what is the nature of construction arbitration, and when the construction arbitration is taking place? So, what are the interim decisions before implemented the construction arbitration?
So, Shubham, what happens is in the construction arbitration, your question is pertaining to interim measures, right?
Right, sir.
So it may so happen interim measures means wherein a party seeks an immediate relief from the court or from the tribunal. So if the arbitration has already started, one has to move before the arbitrary tribunal seeking the relief. So that there is a provision, section 17 of the Arbitration and Conciliation Act. One needs to move an application before the arbitrator, citing the reasons why that application has been moved and what are the interim measures one is seeking. What is the immediate relief? And if the arbitration has not started, in that case, one may move before the court under section 9, seeking the interim measures. So before the arbitration starts, before the arbitrary tribunal is constituted, if a party feels that, let's say, a party has been awarded a contract, and while that contract is enforced, and during the implementation of that contract, some intricacies comes in the project, wherein a party seeks an immediate relief, then one may move before the court, before the arbitrary tribunal is constituted, to adjudicate on the disputes that may come up in that execution of the contract. Then the party is required to move before the court of law to seek those interim measures that are required. So this is how the interim measures comes into the picture in the arbitration contracts.
And so what is the precondition and whose type of case go into the arbitration case?
What type of cases?
Yes.
See, in the arbitration, the parties have to be ad idem. So arbitration means when a party has agreed that their disputes that may come up, even from they may arise from the employment contracts or any type of contract for that matter, maybe the construction contract or any contract. But if the parties have decided that ad idem, that the mode for resolving the disputes that may arise out of the employment contract or let's say construction contract or for that matter any contract, then if they decide that the matter be adjudicated by way of arbitration, there's a clause in their contract such kind of matters are taken before the arbitrators for the adjudication of the disputes.
Thank you, sir, for sharing your worthful information with us. My second last question is for you. Would you like to share some moment that inspired you a lot in your life? Who prompted you to come into this litigation field? Because you have 8-year experience in the field of litigation. So would you like to share some life experience?
So Shubham, as I told you, while my father was posted out of India for 3 years, I was in Lebanon. At that time, I saw the plight of the Indians there. So there were many Indians who were the migrants there, and they were facing very, difficulties. At times, their documents are seized, and they're trying to come back to India, but they're unable to because of lack of paperwork or representation. So I felt very pity for them. But at that point of time, I was very young. But that thought kept on coming, and it intrigued me. So this is something which prompted me that I should take up the law and understand the facets of it, or how we can help the society. So that was one point where I can say that it prompted me to take up the law, and then I started practicing the law also. So just to, bring a difference to the society in whatever little manner I can.
Do you think that law is making society different, or law can help to make the society different?
Yes, Shubham, absolutely. Law does bring a change. It totally depends on the individuals and the people, how they think of it. So a learned society, a learned fraternity, the way we represent ourselves, we represent our country. So law can bring about that change, because it is the people, it is thinking of the people and how they perceive. It is about the implementation of the law. India has every law, but when it comes to the execution or the implementation, we are lacking there. So as a society, we are also duty bound. If we take it in letter and spirit, we can obviously enforce it, and it can bring a change, a positive change.
Thank you, sir, for sharing these beautiful thoughts. There are a lot of law students in our country. So would you like to share some tips for, especially for those law students who come into the litigation field, basically?
Shubham, students after completing their law come into the litigation. So what we learn in the law school is a totally different picture than what we practice. When we start practicing, we understand the intricacies of the law. Reading law is something else. But when we start practicing it day in and day out, we understand the intricacies that are involved. So it is my suggestion to the young lawyers who come into the practice to have patience and not to be choosy in the very beginning. Nowadays, we see that there is a perception that young lawyers, they want to practice a particular field of law. I may sound a cliche here, but it is my suggestion that initially, at least for, let's say, 10 to 12 years, one should be practicing in different facets of the law. That is the beauty of the law. At one day, you're working on a criminal matter. Next day, you're working on a civil matter. Day after that, you're preparing a constitution matter. So that is the beauty of the law. So it is my personal opinion and my suggestion that one should not be very choosy at the beginning. Maybe after a certain years of experience at one point of time, when you think of specializing on one facet of the law, one can take up that specialization. But from the very beginning, one should be open to all the avenues and the work that is, assigned by the client. And so that is my suggestion to the young lawyers.
So thank you, sir, that you inspire you a lot, and your video will definitely inspire you for those law students who want to something achieve in his or her life.
Thank you so much, Shubham, for having me here, and it would be my pleasure, and I would find myself, if I can bring about some change, I would feel that through your medium, I have been able to, converse with the young lawyers or make a change. And very thankful to you for having me here on your channel. Thank you so much.
And thanks to you also, sir.
Thank you, Shubham. Thank you.